matters to businesses in this country, primarily surrounding business, law and the economy. We're continuing today with Greg Dunstan of Dunstan Legal to keep recapping the Supreme Court case. You would have watched day one yesterday, and we'll roll straight into day two today. If you can hear me okay, or if I might be having some trouble, if you just let me know in the comments if you're able to hear me or not.
Can you bring? It's all right.
But otherwise, I'm gonna hand over to Greg.
Anthony, I can hear you, but I can't make out what you're saying.
That's the problem. I'm going to hand over to you.
Is anybody else having the same problem?
Just go into it, Greg, if you can.
I'm just hoping it's not at my end, but I'll just see if it's.
All right. Well, maybe while Greg's sorting that out, I just want to give a bit of a shout out to the viewers and the amount of support that we've been getting over the last few live streams we've been doing. Thank you a lot for liking and sharing and commenting. All the good reports sort of let us know that we're traveling in the right direction and we're getting the information from the source to the people that need it in the most efficient way. And so thank you very much. And thank you for all the comments and the private chats that people have been having. It really means a lot to know that that people are finding what we're doing valuable as well. I'll just see if Greg's a bit ready to go now. Is that better, Greg? Are you?
Okay. Where it was. I can just hear you, Anthony.
So that's okay. I'll hand over to you at this stage anyway, and I'll let you get into it.
If you can check that it's not me by asking if anyone else is having trouble hearing.
Everyone else seems to be okay.
So can everybody else hear you clearly, because I can't?
Yeah, everyone else can hear. Yeah.
Okay, well, I can hear you now too. All right, great. So just let me know when you want me to start.
Yeah, go ahead. Go, Greg, go now, if you're ready.
Go now, all right. Well, hopefully it's not my modem at this end that's causing the problem, and hopefully everybody else can hear me. Yesterday we got up to the end of day 5 in the hearing, and we dealt with the evidence of Dr. McCartney and Dr. Gale, and the next person that was cross-examined on day 2 was Catherine Boyd, and I'll just deal with her evidence very briefly. She's the Cabinet Secretary, and she's been held that position since April 2019. In a very brief summary, Mr. King was seeking to establish in his cross-examination from her evidence that the public health orders were not the result of a truly independent exercise of the Minister's discretion under the Public Health Act, but they were merely a box-ticking exercise by the Minister pursuant to a partnership agreement that the state had signed with the Commonwealth government as part of Operation COVID Shield, and that he was really just doing the bidding of the Commonwealth. He said that under the agreement, the Commonwealth was to do all of the hospital funding, or rather it was to be a joint responsibility, and the state deferred to the Commonwealth because the Commonwealth was paying most of the money. And that if there was to be any variation to the agreement or the partnership as he described it, that it would not be done without the Commonwealth agreement. And the state was merely responsible for administering the process and the vaccines under the National Immunisation Plan. With the Commonwealth sourcing the vaccines, paying for the vaccines without any cost to the state or the consumer, so that the plan would phase out at 80% vaccination. So later on, he submitted that the order that was purported to be made under Section 7 of the Public Health Act, which was the New South Wales legislation, was not really the path that the minister was taking, that he was really going down the path of a Commonwealth state joint partnership agreement, where the Commonwealth and the state would effectively, as he said, joined at the hip. He cross-examined. His cross-examination of Catherine Boyd as the Cabinet Secretary was along the lines of attempting to set up the facts that would support that submission. Then the last person that was cross-examined was Mr. Darius Everett, and he was the Acting Secretary for Immunisation and Communicable Diseases employed by the Commonwealth. He stated that medical practitioners report direct to the immunisation register, and Mr. King noted to him that the register handbook required that there be a valid consent from an individual before their immunisation status could be disclosed to a third party. Mr. Everett stated that his role was to ensure that the register was adequate to administer the vaccine. He wasn't involved in any COVID-19 task forces, but that the states used the register that he was in charge of to check vaccination status. So that was the final part of the cross-examination of the witnesses for the minister. And the case then moved into what are known as submissions. And there are three lawyers who are making submissions for the plaintiffs. The first was Mr. King, SC. The second was Mr. Clark, QC. And the third was Mr. Clark's junior assistant barrister, Dr. Harkis. So when I say these names, King, Clark, and Harkis, just know that they're the counsel representing the plaintiffs. The counsel representing, or the senior counsel representing the plaintiff, the defendant rather, the minister, was Mr. Kirk, SC, and his junior assistant counsel was a Mr. Prince. So these are submissions that are being made to the court, and they're being made by Mr. King for the plaintiffs. So his first submission was that the plaintiffs' lay and expert witnesses were of a character and unquestioned because they hadn't been cross-examined. So there'd been no cross-examination of any of the plaintiffs' lay witnesses or the plaintiffs' expert witnesses. So this submission went to the fact that he was saying that therefore everything that they said should be accepted because it was unchallenged. He said that the plaintiffs have been forced by coercion or manipulation against their will as at pain of losing their livelihoods. One of the plaintiffs was a sole breadwinner, and one of the other plaintiffs was giving birth the very day that she was being terminated for not being vaccinated. He said Parliament hasn't endorsed this approach. If the Public Health Act and the Parliament wish to take these rights away, there must be clear and express words used in the legislation. And if Parliament wanted to confer a power to authorise what he said amounted to the tort of battery, which was the coercion to have a needle injected into a person, or an assault, the legislation would have made it clear and express. He said Dr. McCartney, who was the main witness, expert witness for the minister, had never treated a COVID-19 patient, and she's actually separated from the COVID-19 section in her hospital. He said the plaintiff called overseas experts because Australia had fallen behind. He said one of these experts was a Dr. Tyson, who had treated over 6,000 patients, and treating the patients without vaccine, or actually, no, I think they were vaccinated and unvaccinated, but it established that it was an effective treatment because of those 6,000 patients, only 4 people had died. And of those 4, they had comorbidities such as age, illness, or they were just simply being treated too late in the progression of the disease. He said that Dr. McCartney rejected this weight of evidence in one sentence in her report or her reply. He said McCartney acknowledged that the vaccination does not prevent transmission and that the minister should have made inquiries into alternatives to vaccination, such as the treatment that Dr. Tyson had conducted with his 6,000 patients. His Honour stated that noted that Australia doesn't have widespread natural immunity like other places because of the low case numbers. And the implication may have been that we're only left with vaccines as a viable alternative. Mr. King said that the vaccinated actually have less antibodies than natural immunity, and vaccines wane over time. He said the state is guilty of legal unreasonableness by its failure to follow a line of inquiry and choosing to adopt a one-size-fits-all approach. He said that an adverse inference should be drawn against the minister because he said, or the minister said, that he would produce documents that were the subject of a notice to produce and then had failed to produce them. Mr. King said that the purported exercise of the power under Section 7 of the Public Health Act was not really under that section. And what the government were really doing was going down a different path under the national plan, being the health sector emergency response plan between the state and the Commonwealth. He said on the same day the national partnership was promulgated and agreed. So they went down this pathway rather than the purely state pathway under the Public Health Act. His Honour stated that the agreements are dealing with outcomes and not the state processes to implement the agreement. And I think what His Honour was saying there was that they might have had an agreement to go down a certain path, but it was still to be implemented under the State Health Act. Mr. King said that the Commonwealth supplied free of charge to the state, so that it was clear that the state had decided to move down this pathway. Now, this is relevant later on because when it comes to the question of what's called conscription of medical services, because Mr. King later tried to link the prohibition against the Commonwealth conscripting doctors and patients into medical service with the action taken by the state. So that part of Mr. King's argument was that because they were joined at the hip, that the state implementing these things was the same thing as the Commonwealth breaching the restriction under the Constitution. So he said that in fact the New South Wales implementation plan in December 2020 was actually drafted by the Commonwealth. And any updates or changes to that plan had to be approved by the Commonwealth. So his submission was that effectively the Commonwealth were in the driving seat. He said that the full federal court has stated that an exercise of a discretion by the minister must be an active intellectual process. It can't just be a box-ticking exercise at the behest of the Commonwealth. He said the legislature would not take away individual rights without unmistakable language, and the right to bodily integrity is a fundamental principle in that every person's body is inviolate. He said that Mr. Nikolic had sent a letter to the minister that set out the key human rights instruments so that the minister was on clear notice of these matters, but Mr. Nikolic didn't even receive an acknowledgement of the letter. His Honour commented in passing that he could see the coercive effect upon the right to work and freedom of movement. Mr. King continued and said that the House of Lords in Airedale, in a case of Airedale, which involved mandatory artificial feeding devices, was held by the House of Lords to be invalid because it was essential that the court respected the wishes of the patient, which had to be adhered to irrespective or however unreasonable that might be. Mr. King said that even though the orders do not directly mandate vaccination, that is their effect, and that it's their effect that the court should look at. He said that Justice Hunt stated in another case that a form of duress can be if a person has lost their free choice because the consequences of the threat are greater than the risk. Mr. King said that the Section 8 of the Public Health Act grants a bigger power than Section 7. Now, Section 8 of the Public Health Act permits a forced medical procedure, but the forced medical procedure is not vaccination. It's well below that. It's medical examination. So Mr. King's argument was that if Section 8 can't even permit vaccination, then Section 7 certainly can't. Mr. King said that even Section 7 requires that there be a declaration of a public risk area, and that no such declaration had been made. I will say that the Minister argued that the orders themselves amounted to such a declaration even if he hadn't made an express declaration. Mr. King moved on to the unreasonable nature of the orders. He said that the failure to investigate alternatives when the approval of the vaccines was only provisional was unreasonable. He said the fact that a unitary approach was taken is evidence itself of unreasonableness. That expert evidence was available to the Minister at the time, and it was not reasonable for him not to have considered it, as, for example, in Mr. Nikolic's letter to the Minister. He said Mr. Kirk for the Minister said the Minister did not have to consider them, and it was just about the merits of the Minister's decision, that he had the power to do it and that the court had no power to interfere. Mr. King said, though, the rights of the citizens are much higher than that, and it is the role of the courts to stand between the citizens and the government. And in this case, the line had been crossed. He moved on to deal with infections. And he said, the fact that the vaccinated can be infected has not been contradicted. He said that the Minister could have crafted orders to take into account the infectiousness of different age cohorts, such as those under 40, whose rates of infections are only slightly lower than the vaccinated. And he said that therefore the orders could have dealt with them in a different way. He said that vaccinations wane over time and that after 146 days, the effect of the vaccination expires. He said it's legal unreasonableness that there is no black and white outcome resulting from the orders that were made. that Israel are up to their third booster, and in some cases their fourth booster. He then moved on to the question of transmission. He said, it is said that the vaccines inhibit transmissibility, but if mandating vaccines is at the price of people's livelihood, it is legally unreasonable when it does not eliminate transmission and merely inhibits transmission. The High Court, he said that it is legally unreasonable not to take into account and to engage in a line of inquiry, such as treatment. The court needs to rule on this so future decisions are taken properly. He also stated that it was of great disappointment to him that the federal government had not been more involved in the case. He then moved on to a constitutional argument, and it's complicated. So I'm going to do my best to explain it. He then turned to Section 51(23) capital A of the Constitution, that is part of the section that deals with the powers of the Commonwealth to make laws. And one of those powers of the Commonwealth is to make laws in relation to medical and dental services. But there's a rider to that, and the rider is, but not so as to authorise any form of civil conscription. So Mr. King submitted that this power prevents a power in relation to medical and dental services. And in this case, the Commonwealth and the states are compelling medical services through the use of medical practitioners. He said, one can only leave home in areas of concern with a vaccine certificate. One must go to a doctor to obtain 2 doses, and if they don't, people in those areas cannot work. The medical services include 2 things: the provision of the vaccine and the provision of information to the immunisation register. The Commonwealth pays for the service. His Honour said at this stage, none of the doctors are saying that they are compelled to vaccinate. Mr. King said, but the effect of the order is to conscript the medical cohort to work with the government. The orders conscript patients as well, and their doctors at the price of not giving up their livelihood. It is not appropriate to take a limited interpretation of the restriction. Later on, Mr. King submitted that and put a hypothetical to His Honour when he said, what happens if one goes to their doctor and tells them that they, as the patient, don't really want to have a vaccine, but they've been coerced to do so by the doctor? There is then moral coercion on the doctor to give the vaccine, otherwise his patient will lose their job, even though the doctor knows that the patient is being coerced. And that was Mr. King's argument as to why that this procedure involved a civil conscription in relation to medical and dental services. He said the section is not just to protect the doctors, but also the patients. And the Commonwealth is asking the state to apply civil conscription as its agent and on its behalf. In relation to the Immunisation Register, the Australian Immunisation Register Act registers all immunisations in Australia. The register cannot accept a registration in circumstances where there is any element of civil conscription in breach of the Constitution, so that Section 7 of the Public Health Act cannot authorise civil conscription. Mr. King said there therefore needs to be informed consent in order to prevent it being civil conscription. He said this prohibition upon the immunisation register has a downstream effect upon the state law that permits it. Protection from coercion he said, was also in the immunisation handbook itself. He quoted from the House of Lords the statement that laws that prevent people from going to church but permit liquor stores to be open are disproportionate, unreasonable, and beyond power. So that was Mr. King's submissions, and the next line of submissions were Dr. Harkis. Now, Dr. Harkis wasn't Mr. King's assistant. He was the assistant for Mr. Clark, QC. Dr. Harkis said that he would be dealing in his submissions with bodily integrity, the right to work, and the right to freedom of movement. He said that the prevention of a perfectly healthy person from going to an area with no disease is not reasonable. He said even Section 8, which is the more powerful section than Section 7, and which has much more coercive power than Section 7, only allows a forced medical examination, but not a forced treatment. Therefore, how could the lesser power in Section 7 be used to go further and effectively mandate treatment by vaccination? He adopted the reasoning of a recent decision in the Fair Work Commission by Deputy President Dean in the case of Kimber, that bodily integrity means that consent is required to become part of a clinical trial. And his submission was that this is a clinical trial because the vaccines are only provisionally approved, and that no person can be compelled to partake in a clinical trial. In relation to the right of work, he said the right of work is traced all the way back to the Magna Carta. I think when the King guaranteed the right of the servants to be able to work. He said, in addition to this has been codified in Article 6 of the International Covenant. In relation to rights against discrimination, he said the Section 7 doesn't allow the minister to make orders that amount to discrimination. The orders are discriminatory between the vaccinated and the unvaccinated. He said that the definition of discrimination in the Disability Discrimination Act includes the prospect that you may be disabled in the future. The denial of access of perfectly healthy people can only be on the basis that you may be disabled in the future. So I might just read a pertinent point out of the definition of disablement in the Disability Discrimination Act. It says that a person is disabled if by the presence in the body of an organism that's causing disease or illness, and that this disability may be a disability that presently exists, previously existed but no longer existed, or may in the future exist. So what was being said here was that to effectively mandate vaccination of perfectly healthy people without COVID-19 could only be because they may be infected in the future or they may be disabled in the future. And that felt squarely within this extension of what being disabled was, namely that this disablement is even if you discriminate about this disablement that may exist in the future, it's still discrimination. In relation to Mr. King's medical conscription point, he said that it is the patient that is being conscripted into the medical service. He said they are said to be providing the medical service of contributing to herd immunity, and they are therefore being conscripted into the public health system by virtue of that reason. And that the legislation prohibits any form of conscription. And he said those words, any form, were important because they meant that it wasn't a narrow form of medical conscription that the Constitution was talking about. In relation to privacy, he said that the obligation to produce a vaccine certificate is in breach of federal and state privacy laws because it requires disclosure of personal medical information. He said the vaccination details can only be accessed with the consent of the vaccinated, and any purported consent cannot be valid if the person has been coerced into obtaining it. The Commonwealth are well aware of this because they know that the Minister has made these directions. Furthermore, no organisation is by law able to gather medical information unless it is related to that organisation's function. For example, the function of a school is education, not safety or medical, even though those things might be ancillary to the function of a school. It is still not the function of a school. In relation to self-incrimination, he said that if evidence of vaccination is not provided upon demand, it is deemed to be an offence subject to criminal penalties. So that by remaining silent and engaging the right not to self-incriminate, you are actually committing an offence. Now, His Honour intervened at that point, and His Honour said they're not being required to say anything, they're being required to do something. He said that the Minister, having taken into account irrelevant matters, is evidenced by his press statement that those not vaccinated are self-entitled and indulgent in the extreme, meaning that he did not recognise the rights of those refusing to have a vaccine and therefore couldn't have taken them into account when considering what action he should take. In relation to the denial of natural justice, he said that there had been plenty of time between the outbreak of COVID in early 2020 and the making of these orders in August 2021 for there to have been public consultation about this. But he said there hadn't been any public consultation in relation to, for example, alternative ways of approaching the problem. And he said that constituted denial of natural justice to those affected. The Crown, I must say, said that it was a nonsense to say that you had to provide public natural justice to 8 million people, and that it was really only appropriate in relation to individual cases. Now, at this point, Mr. Clark, who was Dr. Harkis's senior counsel, then began his submissions. He also said that the orders were not reasonable or proportionate. He said they failed to take into account relevant considerations, including the lack of efficacy, the lack of safety, and that it failed to take into account alternatives. He said it also failed to take into account the countervailing factors, or what's colloquially called the cons. There are the pros and the cons, but only the pros were looked at. He said all of the factors presented to the Minister were all one way. There was no evidence presented to him presented by him or his advisors as to what he took into account. He failed to take into account the lack of scientific certainty as to the efficacy and the safety, and as to the transmissibility. He said that the fact that the vaccines attenuated the severity was not relevant. He said, unlike traditional vaccines, this vaccine is short-term and there are ongoing trials in relation to safety. And then he quoted from a TGA publication. And my opinion was that this was a fairly significant point with the court. He said, and quoting from the TGA publication, he said, the vaccines with the immune compromised haven't been assessed because they weren't part of the trials. He said the duration of protection hasn't been established. Once again, this is in the TGA document. That limited data for the elderly who must be dealt with on a case-by-case basis, taking into account comorbidity and age. That the TGA document said that there was limited data for persons with comorbidities. That it said there is no data for safety in relation to persons under 18. That it said there is no data as to the interaction of the vaccine with other medications. That it said that there was no data in relation to fertility. That it said that the studies in relation to pregnancy have not been completed. That it said that it was not recommended to be participated in during pregnancy. That it said that there was no data in relation to breastfeeding or the effect on the infant, and that there was a low representative number in the trials of the frail and the elderly. It said that there were ongoing clinical trials happening, and that the trials excluded people with liver, renal, neurological, heart, and immune problems or diseases. That the participants of the trials were to be followed up 12 months with the side effects or any side effects to be studied. That the participants over 65 were too few to determine efficacy, and further surveillance of that age cohort was required. And that immunological protection was unknown, and that genotoxicity studies have not been conducted, damage to DNA, replications, cancer, or birth defects. So there's this is my comment, a fairly horrifying list of unknowns. Mr. Clark said that the serious side effects are still being studied in clinical trials. That the UK advised their healthcare professionals that there is no data for the Pfizer effect on reproductive fertility, that is not recommended for the pregnant, and to avoid vaccinations 2 months before pregnancy, and that the risk of breastfeeding with an infant is not known. He said that the plaintiff's expert, Dr. Parks, has stated that the data on the Delta variant are not yet available. That Dr. Parks refers to the Powell report. Now, the Powell report is the report that Dr. McCartney, who was the minister's witness, relied upon herself. But he said that in that Powell report, there was a section which said that the Delta and the infectivity of the vaccinated and the unvaccinated is not known and needs to be urgently evaluated. He also quoted from another report called the Liu report that was compiled by 24 scientists, and the part of the report that said that the Delta strain has completely escaped the vaccine antibodies. That in relation to preventing infection, the vaccine does not appreciably affect the outcome, and that the studies were only based on, the earlier studies were only based on symptoms of a virus which no longer exists. Also, that natural immunity is 13 times more effective against the Delta variant. Mr. Clark also submitted that Dr. McCartney's evidence was more in the nature of an advocate for the minister than an expert. Now, I'll just explain here that a court an expert witness that appears before a court has to be objective and impartial in expressing an expert opinion. So what he was saying here was that her evidence wasn't impartial or objective, and that it was more on the nature of her being an advocate for the minister. He said Dr. McCartney disagreed with almost every opinion expressed by all of the plaintiff's expert witnesses. And yesterday, we read through the vast list of expert witnesses that the plaintiff had called. He said that Dr. McCartney said that the vaccine was safe for pregnant women. He said that Dr. McCartney was effectively cheering from the sidelines for the minister, that she was not objective and that the matters were not within her experience, and she relied upon the experience of others. He said, where there is such uncertainty as this, mandating is not appropriate. Now, the next person to make submissions was Mr. Kirk. Mr. Kirk, as I said, was representing the minister. He spoke about the lucky ones who were permitted to leave the areas of concern. He said that because the 19 plaintiffs had not been vaccinated, they had in fact not been coerced. He said they have a choice, like the choice of whether to drive on a road and get a license, without which you don't have the freedom to drive a car and your freedom of movement is impaired. He said, in any event, the orders are only temporary and they expire after 90 days, which is this coming weekend. In fact, Sunday morning. This Sunday morning. He said that there is an exemption which allows people to work and to leave the area. He said it's not self-incriminating to remain silent because the legislation or the orders don't require anyone to say anything. It only requires them to produce something, namely evidence of vaccination. He was asked the question, when it says that you can't be at an aged care facility unless you're vaccinated, in fact, I think it was the judge that asked him this question, does being at the aged care facility mean physically at or remotely at the aged care facility? And Mr. Kirk expressed the opinion that it was physically at. He said, and that might be helpful for anybody that's in the aged care industry to know that, or that that's his opinion. He said, if the orders were so draconian as the plaintiffs say, why did it have a 90-day sunset date? However, the orders do have the potential to be extended or further orders made. So time will tell what happens after this coming Sunday. He said nothing in the orders requires a medical examination. He said the requirement in Section 7 for the minister to make such orders as are necessary does not mean that they're necessary in the view of the judge, but in the view of the minister who is responsible to the electorate. He said that there are limits on what the minister can direct, but the limits are generous and they don't involve the court being involved in an administrative law review. He said there are a range of possibilities which may be too harsh or they may be too soft. He said there's no right answer. And he says, where is that line to be drawn by the minister? His Honour said, these claims are much more focused. They're focused on the discrimination between the vaccinated and the unvaccinated. Even if you overcome the submission that the minister lacked power under Section 7, you still have to justify discrimination between the vaxxed and the unvaccinated. Mr. Kirk submitted in his response that the courts are not appropriately enabled to review the minister's decision. He said that international instruments don't apply to Australian law. And I will say that later the judge backed that up because that was the judge's opinion as well. He said the plaintiff's case is all about them and not about the community. He said even in the USA, which has a Bill of Rights, mandatory vaccines have been upheld. He said the principle of legality is only one principle amongst many, and it doesn't trump the other principles. He said the orders must have a rational relationship to the risk. He said, for example, it would not be rational to shut down the whole state over gastroenteritis, for example. He said that you cannot say that the minister had to consider the experts' opinions. He said there are millions of opinions out there, and even respected experts disagree. He said, given the material that the minister had, he made an appropriate response. He said, so what if there are experts who hold a contrary view? He said the requirement of reasonableness is not breached when it is in relation to a matter about which reasonable minds might differ. He said Dr. McCartney's CV shows that she is a true expert of international standing and is an expert in relation to immunology. He said it's just not possible to have certainty with COVID-19. He was addressing the plaintiff's argument that these measures shouldn't be taken where there's such uncertainty. His Honour said, do you accept that there are uncertainties? The defendants say that there are uncertainties. He said, there are always uncertainties in science. Newtonian physics was certain until it wasn't. He said, Dr. McCartney said that we don't have the studies yet on breakthrough cases, but we can infer from the studies of previous strains that they would equally apply to the Delta strain. He said the minister does not have to describe the procedural steps that he took in making his decision. He only has to state the reasons for his decision. He says there is not a reason to believe, or there is no reason to believe that the ministers did not agonise about their decision. He said Mr. King did not show one document whereby the Commonwealth required the state to impose a vaccine requirement. His Honour said the National Cabinet agreed to vaccinate aged care workers. Mr. Kirk said it was an agreement is different from a requirement. There was no threat to withhold funding or anything like that. He said the states are not bound by the civil conscription rule in the Constitution. He said states are not bound when acquiring land to offer just terms. I must say, when I heard that, that gave me a jolt, that the state is not bound when acquiring land to offer just terms. It would be amazing if there was an implied right to bodily integrity, he said. His Honour then said, coercion is not proper consent. Mr. Kirk said there has been no vaccination mandate. Economic pressure, yes, but reasonably appropriate and adaptive. He was asked, can vaccines be mandated? Mr. Kirk's opinion was probably yes. If there was something like Ebola that had a 50% death rate. The next person to give submissions was the barrister representing the Commonwealth, the Joanna Davidson. I'll deal with her submissions were relatively brief. She said that the rule against civil conscription of medical services in the Constitution doesn't bind the states. So it's apparent from that why Mr. King was making the link between the actions by the states being effectively the actions by the Commonwealth, because they were joined, he said, they were joined at the hip. She said, you cannot prove that the feds have conscripted those services, or that the federal government have required the state to take that action. She said that the section only prevents nationalisation of healthcare services, and mere joint action with the state is not enough. So that was the end of the primary submissions. That was then followed by submissions in reply. So in these cases, the plaintiff has the right to make submissions, the defendant has the right to make submissions in response or in reply, and then the plaintiffs are allowed a further chance to make responses to the defendant's submissions in reply. So these submissions that we're entering into were the submissions by the plaintiffs in reply to those submissions that I've just gone through by the Minister, or on behalf of the Minister. He said, this is Dr. Harkis, that the court is required to assess the extent of infringement upon private rights, which the Parliament intended under the power it gave pursuant to Section 7. For example, masks, quarantines might be legitimate, but vaccination by coercion is a step too far. He said limitation of movement outside an area obliterates the ability to earn a living, and it's artificial to say that it's merely a limitation on restriction of movement. He said the orders turn skills which people have spent a lifetime developing to dust. He said the infringement upon bodily integrity amounts to the tort of battery. And you may have heard the expression assault and battery, and this is what he's referring to when he says battery. He said there's been a Supreme Court case in Canada that was about a doctor treating the drug addiction of a female, which the doctor used to develop a sexual relationship with her. She sued him for battery, and his defence was that it was by consent. He said that the court, in considering whether consent had been given, it would need to take into account the following. And those factors were whether there was a position of relative weakness that might have impacted upon her will, that consent deals with the power relationship between the parties, and that the notion of submission to an authority figure indicates an inequality of power so as to bring into question the issue of consent. In that case, the woman was found not to have consented. Dr. Harkis therefore postulated, are the vaccinated truly in a position to make a free choice? Was there exploitation as in the Canadian case? There must have been. In the case, his knowledge of her problem, where she was motivated by a craving for drugs, and by using his power in the situation, removed any possibility of meaningful consent, according to the decision by the Canadian court. The power imbalance between the minister and the plaintiffs, Dr. Harkis said, and those vaxxed who have submitted to those directions have submitted to an authority, being the minister's authority. It is exploitive. The plaintiff is saying that it is exploitive because the minister has used Section 7 to prohibit my workplace and ability to earn an income to achieve his ends of achieving 80% vaccination in order, and by this, have me get a vaccination. His Honour then stated, there is no power imbalance, however, if a person is applying for a job. And I think the word applying for a job is important because that would be different from a person who already had a job. In relation to privacy, when a person downloads their vaccination record, he said, from the immunisation register, they're not doing it of their own volition. They're doing it because they need the vaccination certificate to keep their job due to a direction of the minister. The person is in fact doing it as the agent for and on behalf of the minister. And he said the privacy principles require the immunisation register to take reasonable steps to protect information. And this would include taking into account that the immunisation register were on notice of the terms of the minister's health order and the potential that they were receiving information obtained due to coercion. He said the privacy principle 1 states that an organisation must not collect health information which is not directly related to its function. He said businesses who have no health function may still keep these records in order to show that that they've complied with the health orders. He said privacy principle 1 states that an organisation must not collect health information if it's not directly to its function, and the businesses will keep copies to show compliance, but health is not directly related to their function. He said Section 7 does not permit breach of privacy law. He said uncertainty in relation to the vaccination has been admitted, and this should weigh heavily upon the court's considerations. An individual should decide whether something goes into their body. His Honour said malaria injections are a preconditions to various forms of activity. And Dr. Harker said in response, but in those cases, it is by legislation of Parliament. It is not by a delegated authority given by a minister. Mr. King then had his opportunity to respond. And he started by saying that servitude comes by men, but the right to freedom comes from God. He said the public health order was to get the vaccination rate up to 80%. It was by way of compelling people. There is no more effective coercion, he said, that unless people comply, they are denied a living. He says, if it is a choice, it is only a choice if you don't need to work. He said, it's not a forced injections according to the order, but it has the same compulsion as it is the human instinct to survive. And with criminal penalties, it is the same as if they were ordered to be jabbed. He said it's not a mere incentive, it is oppressive and it is severe. He then referred to a case of a juvenile detention centre in the Northern Territory which had involved gassing as a control measure. The detention centre authority had been authorised to do all things necessary. But the gassing was held by the court to constitute the tort of battery because the statute was expressed in general terms, and these general terms were too general to authorise such an action. Mr. King said that the words of Section 7 do not authorise battery by injection. He said the UK Parliament had the benefit of a debate about these matters, but the New South Wales Parliament has been denied that right. He said the fact that Mr. Hazzard did not even acknowledge receipt of Mr. Nikolich's letter is evidence of unreasonableness. He said Mr. Clerk's glowing reference of Dr. McCartney is unsustainable. She dismissed in one sentence the opinion of one of the few specialists in the world looking at mRNA compared with vaccines that have taken 10 years to develop. She has never done sequencing or COVID treatment, he said. He said Section 7 requires the Minister to take into account the risk and the possible consequences. He said the policy of vaccinate or perish is unsustainable. And that concluded the case. And following that, His Honour reserved his judgment and stated that he would deliver a judgment at the earliest possible opportunity. So, Anthony, it's back to you.
Yeah, wow. I mean, can you hear me okay from where you are at the moment? Has the internet problem fixed itself up?
Yeah, I can hear you.
Oh, that's great. I mean, there's a lot of compelling information in there. I mean, I'm going to refrain from my opinion as well, but I think a lot of people would be drawing their own conclusions. There's a lot of information, especially regarding informed consent and coercion. So I think it's agreed from both sides that informed consent is required and coercion is not a good way to be dealing with things in this manner. And we're just sort of discussing whether this falls into that category or not, is what I'm understanding from what you've said.
That's right.
But look, anyway. So anyway, if that's the whole thing, what I wanted to say next was some questions that have come through. I did watch a live stream earlier today that was Rod Cullerton with Matthew Hopkins from AFL Solicitors, and there was an interesting point that they'd made as well, talking about when it comes to laws and legislation, looking into the future. I'm going to paraphrase, but he had some words to the effect of, we need to be cautious where the laws might lead in the future. And hypothetically, powerful interests could make a man-made virus and release it into the wild, release it from the lab, and then make everyone get the treatment and put the real virus in the treatment. So we need to protect society from that scenario into the future. And I thought he did well at describing the potential risks of proceeding down this kind of path as well. So in relation
to that, I did mention how Mr. Kirk, representing the Minister, stated that in his opinion that it would be lawful to mandate compulsory vaccinations if the circumstances were dire enough. And the example he gave was if there was something like Ebola, which had resulted in a 50% death rate. So that might be something along the lines of what they were referring to.
Yeah, for sure. Okay, some questions are: when do you think that the judge might produce his judgment?
Well, he said that he'd give it at the earliest opportunity. There's an enormous amount of work that the judge has to do. Anyone who watched the case could see the enormous volumes of paperwork that he had in front of him. The legal argument was incredibly complex. It involves constitutional arguments and common law and New South Wales legislation, and the judge has a really hard job ahead of him, especially to do in a short time frame. So I believe that he'll do it as soon as it's humanly possible, but it's hard to say when that might be.
Yeah. So another question: if the judgment goes in favour of the defendant, is there enough information presented in this court case to give someone like yourself some legal ground to contest other things that people might be experiencing with their employment, etc.? Is that how some of this information can be used?
Well, certainly the judgment will be of assistance, because the judgment will set out who was right in these, or who he finds was correct in these arguments, and who he finds was incorrect. It was a multifaceted argument by the plaintiffs, so they might succeed on the unreasonableness point, but they might fail on the conscription breach of constitution point. And
Sure.
his judgment will give guidance going forward as to what the law is. And of course, there's always the possibility of appeals as well. So any appeal from this would go to the New South Wales Court of Appeal, and who knows, it might even end up in the High Court. But that remains to be seen.
Yeah, okay. Another question that we had come through, I think yesterday, was if they find in favour of the plaintiff in this case, what ramifications might that have for other states, do you think?
For other states?
For other states, yes. Yeah.
Well, I'd imagine it would have. It depends on their particular state health act, because this was all turned around the Section 7 of the New South Wales Act. So it was, for example, if you're thinking of Victoria, it would depend upon what the Victorian Health Act said. But I would imagine it would have some application. Okay.
I guess, from my standpoint, I think many people watching too, there's a lot of interesting information, surprising information. Especially the fact that the minister was acting under a partnership with the federal government. Was that a surprise to you to find that out in the case?
Yes, I'd never heard that before. These lawyers that have run this case have done an incredible job. And they've gone down every rabbit hole, particularly Mr. King. Mr. King just went down every rabbit hole. So how he dug up the partnership agreement that had been signed between the state and the Commonwealth is beyond me. But he did it, and he says that it's relevant. The minister and his representatives say that it's not. So we'll wait to see. Okay, we've gone over 7:07, so I won't keep you any longer. I once again want to recognise all the long hours you spent watching, summarising, and even the time you're spending with us to inform us of your findings in the case, or just recapping the case for us. Sorry, and thank you everyone for watching live. Like and share this to as many people as you think could find this valuable, and tune in next week when we've got Alex Cooney on Wednesday at 5 p.m. as well. Also, thanks to my volunteers, people that help out with putting the show together for you all as well. All right, thank you very much. Thanks, Greg. Thanks, Anthony.